Okay. Now, I do understand the things that you guys were trying to accomplish or wanted to accomplish with the private educational advocate. I do, okay? And it sounds like, what you were after ended up working. I mean, you ended up having the school do those things, the public charter Montessori school. At the same time, what you're saying is that they literally ran your grandson out of the public charter school, and that's sort of where I want to know what that would entail, because at the same time later you said that due to the extreme retaliation that your family withdrew him, and now he's being homeschooled. So I've seen stuff like that a lot, so I'm not by any means, discounting how you framed it. At the same time, what I'm always trying to understand with any case. So let's say, for example, I did an initial call for to see whether you had a case. Then my questions would focus on how would you define literally being run out of the public school, and how would you define or give me instances of extreme retaliation? Because at that point, then that would go into whether or not you would have you would be in a position to pursue legal damages under the 504 route for engaging in a constitutionally protected activity under 504 or under IDEA, which is in there. Okay. At the same time, it's not easy to prove retaliation, or everybody would be doing it. And that's the one thing you sort of would keep in mind. Okay, so let's say extreme retaliation. Now understand that anytime you file let's say a federal court case, which is, where I would recommend doing it, you could, I guess, file it under state claims, under state tort claims, but, state courts wouldn't have a knowledge base under these laws like the federal court does. So I would recommend federal court. And at the same time, you would have your argument, all right? And with your argument, at that point, the school would have what's known as their defenses. So anything with regards to retaliation would be considered, let's say, correct on the outset. Let's say the court says, okay, we're going to accept these things as true. Your claims of extreme retaliation. And I'm, because you didn't provide any examples, I'm just going to put it out there as broad. Extreme retaliation. Well, at that point, if the court on the outset considers them true and correct, then it flips over to where the burden is now on the school to explain or provide excuses, reasonable excuses for why these activities were done. And then at that point, the court goes, okay, case by case situation. Were those reasonable excuses to where, the parent perceived them as retaliatory when in fact it wasn't. It didn't raise to that level. It was a reasonable reason that they did X, Y, and Z. And therefore what they would do is point by point, just slap those down. And so that's what a parent always needs to keep in mind, is that there needs to be proof, hard proof, not circumstantial. Some of it can be circumstantial, and then what you would hope is that the preponderance of the evidence that has to be intermixed with some hard evidence and some pretty hard proof that these things were done. And absent these conditions, they wouldn't have treated you this way. Case in point, what was your relationship like with the school prior to engaging the private educational advocate to help you out with your situation. So you'd be able to rely upon that. At the same time, if you had a relationship sort of fraught with, ripples and problems, then at that point, it would be hard for you to sit there and say, to make a stark distinction between, what their policies were and how they treated you or how they applied them, pre private advocate as opposed to post, and that's where I see far too many parents out there, far too many advocates that are on social media encouraging parents to file complaints. File complaints, you need to file a complaint for that. No, not unless you have some pretty stinking good evidence to sit there and back that up. Because then all you're doing is potentially setting yourself up for more problems. And in this situation, by going out and getting a professional education advocate, which I'm not saying you shouldn't have done. These things were fixed. Like I said, I don't know what the extreme retaliation is in order to really understand whether or not that, I would have recommended withdrawing him. I've never encouraged parents to stay in a situation that's miserable for their child or for themselves. At the same time, I just understand I'm a lawyer, so I take a cautious approach in my analysis of anything. But that would be your only mechanism to sit there and push for, let's say, legal damages or a case against the Montessori school receiving public dollars, is if you had hard proof and if you could draw a distinction between how you were treated before and how you were treated after. You'd have to have all of that. If not, now I'm not doubting parent intuition. I'm not doubting any of those things. But at the same time, our legal world is one that relies upon proof, no matter how badly that is being destroyed in our media, in our political realm. Okay? I don't know what kind of standard that's going on right now in our current environment of inquisitions, absent any kind of proof other than circumstantial and wish and hopes. That's not a legal standard. All right. So that's where I would just advise parents to just make sure that if you're going that route and you believe that these things are happening to you, then you need to be very mindful at that time to gather all necessary evidence that you would need in the form of any papers, emails being sent home, anything that you can get your hands on to sit there and support that this is being done to you. And then be able to package it for any attorney looking at it as, this is how I was treated and my child was treated here. This was what happened. I was engaging in a protected activity right here. And then this is how I was treated after that point. You just can't sit there and this isn't willy-nilly law once you get to that point. Okay?